Okay, hey guys, sorry my internet was being a little bit glitchy. So today we're obviously going to be talking about the required Supreme Court cases that you need to know from the First and 10th Amendments for the AP exam. And so these court cases will be everything from Tinker v. Des Moines and Roe v. Wade. And so the first thing that we're going to do is we're going to look at sorry, a little out of breath here. We're going to look at Roe v. Wade. And so Roe v. Wade is a very important Supreme Court case because it has a lot to do with the Fourth Amendment and the right to privacy. And so Roe v. Wade is also something that we have a lot of you might want to say disagreement or controversy over. And it is something that in the modern day is very applicable to discussion about AP US government. And so yeah, so we'll just dive into that first. Oh, Ashley's asking, hi, are there slides? And so yes, there are slides, and I'll make sure to link them to the replay, but for some reason it's being glitchy and it's not letting me put them up. So I'll just go through them on my own, and then they'll be linked in the replay resources, so no need to worry about that. Okay, so first we're going to talk about Roe v. Wade. And so, like I just said, Roe v. Wade is something that is very applicable to the modern day. We're always talking about how the Supreme Court's ruling on another abortion case, and that's what Roe v. Wade specifically focuses on. And Roe v. Wade is a case that took place in 1970. And so there was this woman called Jane Roe. And so this isn't her real name. It's just a fictional name because they wanted to protect her identity because it was something it was a case that was very much applicable to her very life. And so she filed a lawsuit against the district attorney of Dallas County, Texas, and that's where she lived. And his name was Henry Wade, so that's why it's called Roe v. Wade, because Jane Roe versus Henry Wade. And so the reason why she filed this lawsuit was because there was this law in Texas that said abortion would be illegal unless a woman's life was threatened. And this meant that even though she wanted to get an abortion, she wouldn't have access to it because a doctor had to say that her life was being threatened or she couldn't get it. And so she decided to sue the district attorney of Dallas County. And so in the lawsuit, she said that this law violated the Constitution because it was very vague and it abridged her right to personal privacy. And so she, in the case, she argued that the First Amendment protected her privacy, the Fourth, the Fifth, the Ninth, and the 14th. And so the conclusion of this case ended up being that people ruled, or the Supreme Court ruled in her favor. And so it said that in the Due Process Clause of the 14th Amendment, it's completely inherent that a woman has the right to abortion because she has a right to privacy. And so it also says that that right has to be balanced, and it has things like the government's interests in protecting a woman's health and protecting the potentiality of human life is also something that's has to be taken into consideration. And that's what the Texas law was arguing. And so it was found that the Texas law violated the right to privacy. And so in a 7-2 majority opinion, it said that women will have the right to abortion. And so in the modern day, we talk a lot about Roe v. Wade, and it's the reason why women have abortion rights in the current day. And so it's been completely important to people being able to have this right to privacy and protection over their own bodies. And that's why it's so important for people to understand that it's just not something that came from nowhere. It's built on decades of opinion. And so the next case we're going to look to is Gideon v. Wainwright. And so Gideon v. Wainwright is an interesting case because it's about rights when it comes to due process and your right to have protection when you're put on trial. And the important thing to remember is that, like, in America, one of the reasons why we have, like, all these amendments that are specifically targeted towards protecting people's right to a fair trial and having a fair process if they're ever put on trial is because when people were, like, under rule from, like, the British, there was a lot of, like, tyranny, and they felt that their rights were being violated and that there was a lack of due process. So in Gideon v. Wainwright, we see that the Sixth Amendment is the main thing that's like it revolves around. And so there was this man named Clarence Earl Gideon. And so in Florida, he like was charged with breaking and entering, and that was a felony. And so he asked the court to appoint a lawyer for him because he couldn't get one. And the Florida state law said that an attorney would only be appointed if someone was unable, like, mentally to get one. And so the court didn't give him one because he was mentally able. And so he had to represent himself. And so, like, when you think about it, like, showing up and standing and protecting yourself in a trial against someone who has both a law degree and decades of experience and is prosecuting you when you have absolutely no legal experience and just aren't familiar with the process, it's pretty daunting and it's not really fair. And so he was found guilty when he represented himself, and he got 5 years in prison. And so he filed a habeas corpus petition with the Florida Supreme Court and like said that this was like a complete violation of his constitutional right to have counsel, right? Because like he had to represent himself and he wasn't even offered counsel. And so that's why the Florida Supreme Court ended up denying that like request. But in the end, the Supreme Court found that the Sixth Amendment guarantees the right of assistance of counsel to any person in a state court through the 14th Amendment. So it said that like if people can't afford an attorney, like the state has to provide one. And that's super important. And it's like one of the reasons why we have like public defenders pretty much everywhere, because of the fact that the Supreme Court recognizes that like not everyone can afford an attorney, like they're not especially affordable. And so that's one of the reasons why we have such like robust rights when it comes to due process. And yeah, it's why if you ever get arrested and they like read you your Miranda rights, then you have a right to an attorney and you will be appointed one if you can't afford one. So the next one that we'll talk about is a case called Wisconsin v. Yoder. And so this case is actually really interesting because we like a lot of the cases that we talk about, we consider them to be like very like quote unquote like progressive, right? Like they're building upon rights, they're making sure that like people are able to have more access to things. But in this case, it was argued because people wanted to not want to do things. So this case revolves around a Mennonite church, Amish Mennonite church within Wisconsin. And so there were these two people named Jonas Yoder and Wallace Miller, and they were both part of like an Amish group of people, and they were being prosecuted under this law in Wisconsin that required all children to attend public school until 16. So they, like in this group of people, they didn't want to have to send their children to public school because they felt that it was contrary to their religious beliefs. So those like three parents, they were like, we're not sending our children to school anymore until at 8th grade, they wanted their children to stop going to school. So they said that being forced to send their children isn't something that's like fair to their religion, and it was violating their right to be able to practice religion. So the question that ends up being asked in this case is it a violation of the First Amendment to force children to go to school until the age of 16? And if the reason that they don't want to go is because of the fact that it violates their religion. because under the First Amendment, one of the clauses is like the free exercise clause. So you can exercise your religion and your right to religion however you so choose. And so the court ended up deciding, or the Supreme Court ended up deciding, that people have the right to exercise their religion freely, and that outweighed under the First Amendment, however this much the state wanted to force people to go to school beyond the 8th grade. Because and they found that the Amish religion required that children not go to school past the 8th grade, and if that was what the religion decreed, then that is exactly what those people would be allowed to do. Because it's just simply not fair for those people to want to go to school or not want to go to school because of their religion and have to violate their religion just because the state wants them to go to school, right? And so, as always, guys, remember, if you have any questions, make sure to just drop them in the chat or click the Ask a Question button, and I'll make sure to answer them. Okay, so I have a question for you guys. Do you feel that this specific case, Wisconsin v. Yoder, which said that people don't have to send their children to school if it's considered a violation of their religion, is something that should be a uniform thing? Do you guys agree with that decision, or do you feel like in some way the state's interest to have children go to school is something that should be taken more into consideration? And so, as always, just feel free to drop your opinion in the chat box and we'll talk about it. So Ashley says that she doesn't really know because schools can restrict others' religion too. It's more than just sending kids to school. Yeah. So that might be a problem, right? Because if we start denying people's right to practice their religion because of public school, it might turn into something that's a slippery slope and just a situation that is not fair to people wanting to practice their religion. Oh, so Ashley says, my school, people can't wear head coverings, so a Muslim girl couldn't wear a head covering if she wanted to. Oh, huh. That's probably a violation of the First Amendment. Yeah, our school has exceptions for that in the dress code, so you can't wear head coverings unless they're religious. So no beanies, but if someone wanted to wear a hijab, a Muslim girl could choose to do that. Okay. So now that we've established that it is important for both the state to take into consideration the fact that people have different religious beliefs, and also the fact that in many cases, the state might be intending to act in a good way, but that those intentions are not always the best under the Bill of Rights. Let's move on to the next case, which is going to be more about the First Amendment, but in a different way. So the next case we're going to talk about is New York Times versus the United States. And so this case is actually very interesting because it's almost like something out of a spy movie. There's actually even a movie about it, and I can't remember what the movie is called, but I'm pretty sure that someone really famous is in this movie, but I literally can't remember. Oh, so Quinn says, sorry, they were gone. My Crowdcast crashed. Yeah, don't even so I said earlier, my Crowdcast is also acting a little funky. So I'm going to link the slides in the replay. And so you guys can access them from there. But yeah, for some reason, it's just not working. So we're all just following along. So Dakota says, this case is about the Vietnam files, right? Yeah, this is about the Vietnam files. So it's also known as the Pentagon Papers case. And so right now we're talking about New York Times versus the United States. So the gist of this case is the fact that the Nixon administration wanted to stop the Washington Post and the New York Times from publishing these classified documents that the Department of Defense had because they were doing a study about the history of the United States' activities in Vietnam. And so a lot of these like papers or actual papers, I don't know why I did air quotes, like were considered to be classified. And so the Nixon administration also felt that they might be like viewed in a negative light by the public regarding the government. And so Nixon said that this restraint, or it should be like stopped from happening, and that these papers should not be allowed to be printed or released because releasing them would violate national security. So it asked the Washington Post and the New York Times to not actually release them. But this is exceptionally important, and it's something that like people always say that the only occupation that's protected in the Bill of Rights is journalism and journalists. And it's true, and this like case is also something that like bolstered those rights, because in its opinion, the Supreme Court held that the government did not overcome this like presumption of prior restraint that the press had in this case. So that meant that like you couldn't just argue that like national security was being like violated in some like vague way in order to stop reporting from happening when it came to the government, right? So they said that like it wouldn't actually cause harm to American forces or their safety or their lives in any way. And so they didn't have to stop the printing from happening. So, oh, okay. So Dakota says that the movie is The Post. Meryl Streep and Tom Hanks are in it. Yeah, that's the movie. Okay, I don't know why this was like bugging me so much, but yeah. So prior restraint is this idea that you can stop something from going to press if it like violates national security in some like very, very damaging way. So like this example of the Pentagon papers is like pretty much the biggest one that established that. And so it said that like you can't just say it's violating national security because you don't want it to be printed, right? Like there has to be some like real concrete reason, and like you can't just say that like people's lives are going to be lost for like in some like indirect way, because it wasn't inevitable that the forces across the world would be hurt. So the court ruled in the New York Times and the Washington Post's favor. Ashley asked, so the Supreme Court said that the right to free press overrides Nixon, right? Yeah, pretty much. They said that we have to value being able to like report on the government and stuff like that over this vague idea of violating national security. So that's what that case felt. So if we were to apply this case to like the modern day, do you guys have any opinions when it comes to like any modern cases of like whistleblowers and like government leaks happening? Do you feel that when do you feel that we should prioritize national security over the right to a free press? Or do you feel that the free press should always be allowed to publish classified information? And so remember, for this part, there's really no wrong answer because it's just your opinion. So Ashley says, free press should usually override it. Okay. Are there any situations in which you think that free press should not be prioritized? Ashley says she doesn't know. And you know what? That's completely fine. Okay, so the next case that we are going to talk about is called Schenck v. United States. And so this case was held in 1991. And it's called Schenck because, Schenck is spelled Schneck. Schenck. You know what? I'll also type it out in the chat. Okay, That's how you spell it. It's not a very beautiful word. But yeah. Okay. So this case is called Schenck v. United States. And so this case happened during like 1919. And so it was happening during World War One. And if you guys remember, World War One happened from like, or it was like in that era. So there were these two like socialists, and they were named Charles Schenck and Elizabeth Bayer. And so if you guys remember, like during World War One, like socialists, like they were not making a comeback. Like Bernie, Democratic Socialists, that was not the move during the World War One era, because like these socialists were viewed as people that were like destabilizing areas within like Europe. So they were also like cracking down on people's rights. So like being a socialist was not the move. And so when Charles Schenck and Elizabeth Bayer started like passing out leaflets saying that the draft violated the 13th Amendment, which stopped people from being able to like stopped forcing people, it stopped slavery, so involuntary servitude. And it said that the 13th Amendment pretty much meant for like where the draft forced you to like go into the army, that wasn't allowed. So the leaflets said that the public should resist the draft, and if they were drafted, not actually like follow through going into the army. And so it said that you shouldn't actually like take any violent action, just like don't go into the army. And so there was this act called the Espionage Act of 1917, and Schenck was charged with conspiracy to violate that act. And so what that act said, that you couldn't cause insubordination in the military and stop recruitment from happening. And so both Schenck and Bayer were convicted of violating that law. And so it was pretty much saying that they had insubordinated the military, and like because they were telling people to disobey the draft, they were trying to stop the military from being able to recruit people. And so they were found guilty of violating the law, and they said that it was not allowed, it was unconstitutional to convict them because saying this violated the First Amendment. And so the Supreme Court said that the Espionage Act didn't actually violate the First Amendment, and it was just something that Congress was allowed to do because it had wartime authority. And so it said that if there was a clear and present danger, then the First Amendment doesn't protect that speech. Okay, so Dakota asked, does the Espionage Act also deal with the case where the guy burned his draft card? I actually don't know that off the top of my head. If anyone else does, make sure to like drop it in the comments and I'll like convey that. But the Espionage Act just says that you can't like stop the draft from happening, and you can't like try to stop like insubordinate the military. So like it sounds like something that might apply, but like I don't want to give like a final answer because I don't know it off the top of my head. But okay, so this is also like this is the case where like the fire in a crowded theater like came from. Like this is where the justices said that like if your speech is going to cause a clear and present danger, like you can't exercise it. So like if you're in a theater and it's super crowded and you yell fire and everyone freaks out and there's like a stampede or something, like then you're not allowed to exercise your speech in that way. Like you have being prosecuted for that doesn't violate the First Amendment. And that's what Schenck v. United States said. And so it pretty much established that if there's a danger to the public because of your speech, then you're not allowed to like exercise that right. So do you guys feel, and answer in the comments like we've been doing throughout this stream, that that's something that should be fair? Like, do you guys feel that the Schenck and Bayer's rights were being violated in this case and that they still should have been able to hand out their pamphlets? Or do you think that it was decided in a fair way? And so Drop your answers in the comments and we will discuss. Okay, so Ashley says, that makes sense because we do have rights, but not to the point of not hurting, but only to the point of not hurting others. And so Dakota says that they think it's fair. Quinn also think it's fair. Like Ashley says, like the right to have guns, but not to murder people. Yeah, that's true. So like, yeah, it does make sense because we do want to be able to like exercise our rights to free speech and like have opinions on the government and be able to like express dissent if we disagree with the government. But we also want to make sure that like our speech isn't harming people. So that's what Schenck v. United States aimed to do. It aimed to make sure that people weren't actually being harmed by the speech of others. Okay, and so this next case also has to do with people's right to speech within a wartime setting. And so this case is called Tinker v. Des Moines. And so Des Moines is spelled, here, I'll type it out in the chat, but it's spelled Des Moines. There. And Des Moines Independent Community School District was a district within Illinois that pretty much said, oh, I'll start from the beginning. So it was 1996 or 1965, and it was December. And so there was a group of students, and so they decided that they wanted to show their support for a truce in the Vietnam War. And so keep in mind, these kids were like in high school, they were like around our age. And so they decided that they wanted to have like a opinion in what was happening within the US government. So they felt that the best way in order to show their support for a truce was to wear these black armbands like throughout the holiday season. And so they were going to wear them to school. And so when you think of armband, it's not like the sweatbands that go around your wrist. It's like if you were to put a band like right here and it was black. And so they were wearing it in order to have like this public symbol of showing support for the truce, right? Like when you think about it, like if you guys have read like the Scarlet Letter where she's like marked with the like red letter, it's kind of like that. Like it's a public statement done through like clothing. And so they were going to wear it all through December. And so the principals that were like within the school district in Des Moines, they heard of the plan. And so they instated a policy that said that if any student had an armband, they would be asked to remove it. And if they didn't remove it, they would be suspended. And so keep in mind, this policy did not exist within the school district before the principals heard of this plan to like wear black armbands. So it was enacted specifically because of that plan, not for like any other reason. And so these kids wore their armbands to school and they were suspended or they were sent home. And the next day, like another person wore his armband and he was also sent home. And so the kids decided not to go back to school until after New Year's, which was when they planned to end the protest. And so the students used their parents to sue the school district and said that their right to expression had been violated. And they also asked that a court file an injunction and stop the school district from actually like disciplining them. And so the district court held, or the case was dismissed, and then the district court held that it was fair for the school to do that. But then when the case got to the Supreme Court, things changed. So the Supreme Court decided that the armbands were just speech, and it was something separate from the actions or the conducts of those that were participating in it. And so the court also said that the students didn't lose their First Amendment rights to having freedom of speech just because they were at school. And so they said that unless the students' behavior and their speech was interfering with what the students were trying to do at school, it wasn't allowed to be silenced. So wearing black armbands and not like specifically interfering with the school day isn't something that like hurts lesson plans from happening. And so the rule was just intended to stop any like disruption from happening, but no disruption actually happened. So the Supreme Court said that students would still have the right to have their First Amendment and their speech within a school district, even if that speech could potentially be something that others disagree with. And as long as it doesn't cause attention to be taken away from lessons or disrupt anything, then it's completely fine. So, do you guys feel that this specific ruling is something that you agree with? Do you think that that political speech should be completely banned in schools? Do you guys think that people shouldn't be able to talk about religion? Okay, so Quinn says, Quinn, Dakota, Ashley, everyone seems to agree. Like, it's completely fair. Like, students should still have the right to talk about their political opinions as long as they don't disrupt anyone. So, like, today, like, everyone can wear t-shirts about who they support for an election to school, even if that person is unpopular. Like, you're still allowed to have your right to free speech, and that isn't taken away just because you're at school. Ashley says, we have opinions like adults. We should be allowed to talk about it. Yeah, that's completely right. One of the biggest ways that like people are able to like develop their opinions is by like talking to other people. And the main place where young people gather to talk to each other is school, because we're legally required to be there. So yeah. The case made sure that people still have their right to speech. And so this next case we're going to talk about is called Engel v. Vitale. And so I will once again spell it out in the comments section because it's also spelled weird. So yeah, this case happened in New York in 1962. So just some background first. The New York State Board of Regents said that people could have a short voluntary prayer to recite at the beginning of each school day. And so the prayer like had specific wording that like talked about like God and stuff. And so the reason why this ended up being such like a disagreement was because not everyone that went to the school happened to be of the same religion, right? So if you're like going to school and having this like voluntary prayer being done at the beginning of each school day, but the wording of the prayer is like specific to one religion, then that's not really equal, right? So this organization and a bunch of like other organizations like joined forces and challenged the prayer, and they said that it violated the Establishment Clause. And so, like we talked about earlier, the Establishment Clause is the clause in the First Amendment that says that there can be no established state religion. So if, for example, there's a public school that's like, everyone here has to be Amish, then that's not allowed because the public school is part of the state, and the state in this context is like the government, the country, and that's not allowed because the state / the government isn't allowed to establish any specific religion. So these organizations decided to challenge it because they felt that it's a public school, and so they can't be like asking students to like say this prayer, even if it is voluntary, if it's tied to a specific religion. And so the Supreme Court agreed, and it said that the state / the government can't hold prayers in public schools, even if like participation is completely voluntary, and even if like you don't have to participate, the state isn't allowed to do it. And it also said that it doesn't matter if the prayer isn't tied to a specific religion, because there has to be a separation between the church and the state. And it doesn't matter if it's completely like non-denominational, it violates the Establishment Clause for the the school, the state, in this case, to do something that like establishes a religion. And so like the Supreme Court said, like it's literally none of your business to be drafting any religion. So like stay out of it, you know? And so they weren't allowed to have daily prayer after that. And so the thing to remember is that a lot of states, like, they still feel that you should be allowed to pray at the beginning of the day if that's what you choose. So, like, in Texas specifically, we say the pledge, we say the American pledge, the pledge to the American flag, and the pledge to the Texas flag every day. And then after that, we have a moment of silence. And so the reason why this moment of silence exists is for if people want to like take that moment to pray, then they can, but you don't have to. You just like are quiet for a minute and then there's announcements. So do you guys agree with this? Do you guys feel that schools should be allowed to have their own prayers if they want to, or do they think? Okay, so Quinn says that they completely agree. And Ashley says that people can pray if they want to, but it shouldn't be required. Like, we have a prayer group at school, but it's not organized. Yeah, so like people have clubs, like we have a like club for everyone who's Christian on our campus, and we also have an organization for the Muslim students. So Brandon says, given that this case's precedent exists, how can school-sponsored organizations still hold like morning prayers before school? I mean, if it's a club and it's like completely voluntary, then you have to choose to go to that club, right? Like you are in no way compelled to go. And so it's like voluntary times two. Quinn says, religion needs to be completely out of school, besides like outside clubs that no one's being forced to be a part of. Yeah, and so a lot of people believe in this like separation between church and state, and that's completely valid because like that's part of what America was founded on, because they don't want anyone to be forced to be a particular religion. So we have to make sure that if we're having government services being provided, then they have to be completely like not related to religion. Okay, guys, so those are the major cases that we have to talk about for the 1st through 10th Amendments. And if you have any questions, now would be a great time to ask them. And yeah, just drop them in the chat box and we'll wait it out. Ashley asks, was the Engel guy from the organizations? Yeah, so it was like specifically a group of like Jewish students that like brought the case forward. And so yeah, he was from the organizations of like people that opposed religion or the prayer being held in school. Okay, so it looks like there aren't any more questions. Yeah, so bye guys. Thank you everyone for tuning in. Make sure to check the replay supplies for the slides if you want to take a look at them. Thanks. Bye.